Greetings, family. Welcome to my YouTube channel. Let me just take this time to thank all those who have supported me and continue to support me. And also, welcome to my new subscribers. If you haven't subscribed, please feel free to subscribe. Please comment. Please share. Please press the post notification button so that when we upload, you get notified. Today I will be discussing what we call default judgment. The question is, as you may perhaps have already seen in our thumbnail, the question is, what happens when the other party does not show up or does not appear in court to defend his case, or he does not serve the necessary documents, and at the court date, at the time of the court, or on the day of the court, he's not there to defend his case? What happens? Does it mean that now we will continue to postpone the case and wait for this person to come to court? What does the law say about this situation? Because the thing is, if this person does not appear to come and defend himself, this person that will call the defendant, because he have been sued by the complainant that we will call the plaintiff, obviously there will be an assumption, or we will presume, that this person does not want to defend his case for one reason or another. We may not know, because that person will not be there to explain themselves. This is a situation where we'll only have one party telling the court what is it that he desired the court to do, and the other party is not there to obtain his side of the story. In terms of the law, there is a maxim, which is in Latin, it's called the audi alteram partem rule. What does it mean? This rule means that before the court issues a judgment, the court must hear both sides of the story. That is the general rule. The court must hear what the complainant has to say, and the court must also hear the other side of the defendant, how the defendant responds or how he defends himself regarding this matter that is before the court. It is only when the court has heard both sides where the court can make a decision and issue a judgment. But in a case of a default judgment, this is an exception. It is an exception in the sense that in a default judgment, the court issues an order in favor of the complainant, in favor of the plaintiff, without having heard the defendant's defense. And reason being, because the defendant is not available. But before the court issues this default judgment, which is basically a judgment in favor of the plaintiff, in favor of the complainant, automatically in the absence of the defendant, because the defendant did not submit their response or they are not present in court. Before the court does that, before the court issues that order of default judgment, the court starts by making sure that this person was served. This person being served would mean that this person was aware of the court date. this person was aware that there is a matter before the court against them that they need to defend. Now, the question is, how will the court ensure that this person was served, as we put it in legal terms? Service here meaning that he was given the necessary papers, he was given the letter of demand, he was given the summons, and he did not respond. That is what we call service. And how will the court make sure that this person was served? There is what is called a return of service. Return of service is that document whereby at the time when the person was served, this person was made to sign to put his signature, even the date when he received this document. So once there is a return of service before the court will be satisfied that indeed this person was served, and therefore it means that this person is aware that there is a matter against them that they need to defend before the court. There are instances where this person may be served, or in an attempt to serve them, maybe they're not available, and somebody can receive and sign the document on their behalf. But there are other instances where it is a must that this person must be served in person, that any other person cannot receive the documents on their behalf. For example, with the divorce summons, we cannot have a situation where they were received by somebody else on their behalf. It's one of the exceptions that I can think about at the moment. The summons must be issued on the person of the defendant, not any other person. So now, once there is a proof, once the court has satisfied itself that indeed this person was served, in the sense that, yes, even the return of service is satisfied, is served or presented to the court. Now the court will continue to do its job. But prior to that, I just want to give you an example of a situation whereby somebody is served and they refuse to sign. Like in our last example, where somebody was served with a letter of demand from the clerk of the court, stamped by the court, served by the police, and he refused to sign. What happened in that instance is the police went back and he wrote an affidavit to the effect that, yes, here is a letter of demand which was issued by the clerk of the court, obviously having the necessary authority from the court to issue this letter of demand in the small claims matter. But this person refused to sign. He shouted at the police and so on and so forth. So the police will write an affidavit which will be communicated or which will be presented to the court as a substitute for a return of service, return of service rather, because this person had refused to sign. So, the law always makes provision for things that we would anticipate or sometimes would not even anticipate. Like, for example, we always assume that if somebody is served, they will automatically sign. Some people do not sign. Some of them, they will refuse, like in this case, even shout at the police, shout at everybody else. And the police left without that signature. In the summons of divorce, for example, you can be looking for this person all over and not finding them, not tracing them. The court makes provision for different ways of service, even in that instance. For example, if you are looking for somebody, you cannot trace them, you cannot find them, and you want to file for divorce. And here is a law that says it must be served on the person of the defendant. There are alternatives that the law provides. For example, one of the alternatives is whereby you can issue the summons of divorce through a newspaper. You can put them in a national paper, in a paper in the area where he stays. And this you can present to the court to say, this person, I've been looking for him. I don't know where he is. I don't know where she is. So I decided to publicize the summons of divorce so that he should be aware. And in that instance, the court will also proceed because there's no return of service, but there is proof that an effort was made, even through the newspaper, to make this person aware that divorce proceedings against them have been instituted. Now, once the court is satisfied that indeed there was service, the court will then go ahead and issue a judgment in favor of the complainant. Whatever it is that the complainant prayed the court to order, the court will do exactly that. Now, this is what we call default judgment. In our next topic, we will look at part 2 of this default judgment to check whether there's a way in which a default judgment can be rescinded or cancelled by the court. Is it possible for this to happen? Please, in our next video, we will discuss exactly that. Thank you very much. God bless you.